Welcome to the Human Rights Café. My name is Jacob Sule. When people's rights are tampered with or denied, it means that my rights and yours are being undermined. Hence, we must educate people about their rights. The Human Rights Café is a collaborative virtual conversation of a Right to Live initiative to equip new generation of leaders to know, promote, and protect citizens' rights and dignity of all persons. The conversation seeks to promote human rights, justice, peace, and strong institutions as provided for by the United Nations Sustainable Development Goals. Our goal is to build a nation where peace and justice shall reign and respect for citizens' rights. If you'd like to know more about the Human Rights Café, please join our conversation on Facebook, YouTube, Instagram, and Twitter via @HRightsCafe. Once again, Jacob Sule. Thank you. Hello, everyone. Welcome to today's conversation. This is the Human Rights Cafe streaming live from Washington, D.C. in the United States. My name is Jacob Sule. Today, I have two guests on the show with me who will share their thoughts on the interplay between international humanitarian law, human rights, and the use of force. Ladies and gentlemen, it's a pleasure to welcome Dania Ahmad and Natasha King. Before we go into the chat, Natasha is a fifth-year litigation attorney currently employed at Whiteford, Taylor, and Preston in Baltimore, in Maryland. Natasha has represented individuals in a wide range of litigation matters, including domestic violence, child endangerment, civil rights violations, prisoner rights violations, public defense, and personal injury. She is finalizing a master's in law in international humanitarian and human rights law with American University, where she's focused on violations of personal liberty and humanitarian law. Welcome, Natasha. I'm also joined by Dania Ahmad. Dania is a licensed attorney in the state of Ohio with interest in public service, human rights, international humanitarian law, and international criminal law. She received a JD from Capital University Law School and an MA in International Relations with concentration in international negotiation and conflict resolution from American University. Dania is currently rounding up her LLM in International Legal Studies from American University. Welcome, Dania. Thank you. So, Natasha, my first question will go to you today, based on the issue of the misconceptions between IHL and human rights law. And the question is, there are several misconceptions about the rules of IHL and human rights. Can you briefly explain the distinction and relationship between IHL and human rights law?
Sure. So it gets a little bit complicated whenever you're talking about human rights law and humanitarian law, especially right now, given the current situation in Ukraine. And of course, that's a top concern that people have is the application of humanitarian law as well as the human rights violations that are occurring. And this has been an issue for a long time. So at a very basic level, the important thing to remember is humanitarian law applies in times of armed combat and in times of specifically, generally international armed conflict. So, for example, the situation with Russia and Ukraine, when you have... Sorry?
Yes, go ahead.
Did you say something, Jacob?
Go ahead.
Okay. So when you have an international conflict, humanitarian law applies, whereas generally if you have situations occurring within one international state, then human rights law applies to dictate that combat. So particularly if you have a non-international armed conflict situation, human rights law is thought to generally apply. And human rights law is basically what we think of when we think of human rights, which is the safety of persons and protecting their base rights as humans, whereas humanitarian law does protect that, but it also dictates when different force of conduct can be applied to situations. So when different targets can be made and those kind of thought processes. So that's kind of a basic overview of the difference.
Thank you so much, Natasha, for that. Then my next question will go to Dania. Natasha has set the stage for this conversation, having talked about the distinction between IHL and human rights law. So, what do you think are the applicable rules and guiding rules that operate for IHL and human rights being a U.S. attorney? Can you share your thoughts on that, Dania?
Yeah, so in regards to the use of force, when looking at international humanitarian law, there are essentially two places where you'll find the applicable laws and rules. The first is the 1907 Hague Regulations, specifically Articles 22 through 28, as well as Article 43. And then additional Protocol 1 to the Geneva Conventions. If you look in Article 48 of that, you'll find some applicable laws, as well as Article 13 of the additional Protocol 2 to the Geneva Conventions. And looking at human rights law, there's a few different treaties and conventions that you could look at. The first one is the International Covenant on Civil and Political Rights, specifically Article 6. The next one is Article 2 of the European Convention on Human Rights, Article 4 of the American Convention on Human Rights, as well as Article 4 of the African Charter on Human and People's Rights.
Perfect. Thank you so much for that applicable rules. You know, there are so many misconceptions, and people would usually think that some laws are not applicable to IHL, whereas some laws are also applicable to human rights law. And this will take me to my next question, which is for Natasha. Can you briefly talk about the distinction between civilians who are civilians during IHL? What are civilian objects during armed conflict? And then also on the other hand, who are combatants? And how do you think we can talk about the principle of distinction when we talk about these two perspectives? Yes, Natasha?
Sure. So a civilian is an individual who's not directly participating in the conflict. And without getting too excessively deep in the topic, generally that'll be children, people who are not picking up arms, and anyone who isn't directly assisting in whatever conflict is going on behalf of the government or the resistance or whoever the warring parties are. So those are your general civilian objectives. And in humanitarian law, the restrictions on civilian objectives are you cannot target as a specific target locations that are civilian run. So hospitals, homes, objectives that are specifically civilian in nature. So all of your objectives when you're targeting in a conflict need to be and are supposed to be under humanitarian law military objectives. So locations where there are bases or active fighting going on, those kind of things can be specifically targeted. And under the principle of distinction, you are required to make that determination. And if you don't, then you end up in situations like what we see with Russia and Ukraine right now, where there are hospitals being targeted, when there are shelters that are known to be shelters for non-combatants targeted. So those individuals are off limits under humanitarian law. And that's why we have these rules in place, is to ensure that the people who are being targeted and killed are ones that are intentionally being.
Thank you very much, Natasha. I got something from that's your contribution. You cannot target civilians during armed conflicts, and persons who are not directly participating in armed conflicts cannot be targeted. And you also talked about the principle of distinction, which talks about who is a combatant and then who is a civilian. So these are very important issues, which I appreciate that you've talked about. Yeah, my next question is for Dania. Going from what Natasha has talked about, you would see that essentially human rights law deals with law enforcement, that is the local laws in countries, their domestic laws, while IHL, which is the international humanitarian law, deals with the conduct of hostilities. Now, what are your thoughts about these and the required standard for the enforcement of human rights law in different countries? Yes, Dania?
Yes, thank you, Jake. So as you see in modern contemporary armed conflict situations, we're getting a lot of situations in which armed forces are increasingly expected not only to partake in armed conflicts, but also they're taking over this role of law enforcement operations in order to maintain or restore public security, law and order. And so when you have these armed forces stepping into, a more domestic law enforcement position, that's where you kind of see like the water is getting a little muddy. You're not really sure whether to apply IHL, international humanitarian law, or human rights. And so that's kind of where a lot of people are getting confused on what to apply. And as you'll see, Natasha will explain this a little bit later when use of force can be used in either situations. But just to briefly put it, under human rights law, it really just regulates the resort to the use of force by state authorities in order to maintain or restore public security, law, and order. So it's a last resort, and Natasha will get into this a little bit further, but it's just a last resort in order to protect life. And so, force may not exceed what is strictly or absolutely necessary to protect life under human rights law. And under international humanitarian law, when you're partaking in armed conflict, those laws are going to be very different in terms of what use of force is permitted or not. So right now, that's the big question that a lot of people are having, is when you have these states of non-international armed conflicts or states of occupation, and these armed forces are now taking over a more domestic national security role, which rules do you apply in certain situations? And so that's the big question now that a lot of people cannot really come to a consensus on.
Perfect. Thank you very much. I picked up a couple of things from what you said, that the human rights law is usually more like the last resort for people, and then to guarantee the protection of civilians and citizens during armed conflict. Now, this will take me to my next question, which is for Natasha. Danya talked about when the use of force can be applied, and also for protection of citizens and civilians during armed conflict. So my question to you, Natasha, is when is the use of force applicable in IHL and human rights law? And then can you share your thoughts on instances? There are several issues of armed conflicts going on around the world. Can you be specific about when the use of force is applicable as provided by the additional protocols and the Geneva Convention? When exactly are these rules of IHL applicable for force? Natasha?
Sorry, I was muted. So it's important to note to answer your question, it's important to remember that there's a difference between international armed conflict and non-international armed conflict when it comes to human rights and humanitarian law. And generally, humanitarian law will only apply if it's an international armed conflict. So whenever there is a conflict inside of a state, it is a non-international armed conflict, or a NIAC, and human rights law is largely thought to apply. And that's kind of where we get this conflict about when humanitarian law applies to a NIAC is when the situation has escalated to that is similar to an international armed conflict. And a lot of the issues going on in the international court systems are about, should humanitarian law apply to some situations of NIACs as a complement to human rights law. So generally what we have is that when you're in a NIAC and there is a necessity for control of a situation. So say you have a rebel group in one state and inside of that state, there is a conflict because of the rebel group. The rebel group is perhaps attacking a government facility. Then the thought in the human rights system is that general human rights principles will apply, and that would be under the law enforcement paradigm. So similar as what we see or we're supposed to see in the US, is that police actions are to apply, which is de-escalation and arrest when possible before using any use of force. So in that situation, what you are supposed to see is that officers, a National Guard, whatever force that is controlling that situation, is to come in and attempt to de-escalate the situation, arrest if possible, use other perhaps things like beanbag guns. It's kind of hit or miss on whether it's believed that things like pepper spray can be used. But options that are not lethal are to be used to de-escalate a situation of that nature. And essentially, lethal force, like Dania said, is your very last option. If you have no other options, then you can use force. Whereas if you have an international situation, and in some minds, potentially in a non-international situation, but that's again where the conflict is occasionally. But if you are under a space that automatically applies humanitarian law, like an international conflict, you start with lethal force. So you can go in targeting other military individuals, and that is your base point. And who exactly can be targeted and to what degree that space can be targeted by regular military operations, person-to-person combat, missile strikes, and any of that nature is dictated by an automatic belief that those people are targeted with a lethal result. So I'm not sure if I answered your question. Let me know if I didn't. But that's kind of our baseline. I think I forgot the second half, though.
Yeah. Thank you very much. You actually did so well. I don't know if Dania want to add to what she's talked about. When is the use of force applicable in IHL? Do you want to throw your comment on that, Dania?
I can just give another example. So Natasha and I, we've looked at a few different case studies in where different situations were provided to experts, and just to kind of get their understanding of which law would apply. And so just another example is when there are riots and armed conflict situations. And so let me just put it into context for you. Let's say it's a non-international armed conflict, and there's a demonstration made up of civilians to protest against the government, for example. So there's a big crowd. There's government troops based on the streets just to make sure everything goes smoothly. It's initially peaceful. Then the crowds start to get a little bit riled up. At the same time, there's like insurgency fighters hidden within the crowd, and they decide to take advantage of this and attack the soldiers. So what do you do? What are those soldiers supposed to apply? Are they going to apply human rights law or international humanitarian law? So which paradigm do you apply, the law enforcement or the conduct of hostilities? And something to take into account here is that riots are generally not considered as amounting to direct participation of hostilities. So those civilians wouldn't be directly participating in hostilities just by participating in a riot. And a lot of the experts agreed that you would have to split it. You would have to take a parallel approach. And basically under this approach, the conduct of hostilities paradigm, which is IHL, would be applicable for the use of force against the fighters. But the law enforcement paradigm, which is human rights law, would be applicable to the use of force against rioting civilians. And under that, you cannot target the civilians. But under IHL, you are permitted to target the rioters, the fighters amongst the rioters. But as you can tell, there's going to be some overlap that just doesn't make sense between these two, because incidental damage among civilians is not prohibited, provided it is not excessive under international humanitarian law. But under human rights law, it's not the same thing. There's just, you can't reconcile the two evenly. And so that's the big question here is, even if you can decide which to apply in certain situations, if you're going to have to split it up and take a parallel approach and apply one paradigm for one situation and another for the other, then if they don't kind of reconcile evenly, then how are you going to resolve that? And you have to keep in mind that if this were occurring in a real life incident, these soldiers are not going to have enough time to make that split-second decision and make an accurate decision, even if they were a consensus of what is accurate. And at this point, there really isn't. So there's just a lot of different issues that come with the use of force and how to apply these two bodies of law that sometimes just do not agree with each other.
Right. Thank you very much, Dania, for that, and Natasha. Because of time, I'm going to ask you guys for your final thought. For those who are watching, what would you say to them as a last word for them to understand the distinction between IHL and human rights law? I'll start with Natasha. What is your final thought on the distinction or the interrelationship between IHL and human rights law?
That, we talk a lot, especially in classes, about the differences between the two bodies and the conflict between applying them together. And I just think it's very important to think about that. Although these are two very different initial principles, they start on two completely different bases, which is, war and violence as an automatic and war and violence as a last resort. The good grace of it is that it protects many of the same elements, regardless of which is automatically applied. And like Dania just noted, whenever you see things like ICRC reports and expert comparisons of situations, it's very frequent that they're determining that if they determine human rights law applies, it protects very similarly to IHL in many cases, and especially when it comes to civilians. Obviously not when it comes to combatants, but when it comes to civilians, there are protections under both measures. And so although we have a lot of confliction about the interplay between the two bodies and the fact that our international human rights courts have dictated that even though a case in the human rights courts might come out of a conflict situation, they're only going to apply human rights law. Many of the times they'll use IHL as an interpretive principle, or at least if they are outwardly saying that they're not, they are at least applying logic that we would hopefully see from the same source. So I guess my last comment would be that at least there is some hope that this kind of interplay will be increased in the future, and that courts, especially when we see lots of active conflicts going on, courts will be more open to applying both principles.
Thank you so much. Yeah, Dania, your last thoughts?
Yeah, I just want to briefly mention that before and after the use of force, there are some obligations under both international humanitarian law and human rights law, such as preventative obligations and obligations to investigate once use of force is taken, to ensure compliance with the applicable laws. So there are some safeguards put into place, and there's a lot of overlap in that sense between the two bodies of law. Just in general, as is most international law, it's going to be confusing and there's not that much of a consensus all the time. But as Natasha just mentioned, that there are going to be some overlaps that do kind of provide the protections that you would hope for civilians at the very least. Even if sometimes it's not very clear whether you're applying it under IHL or human rights law, but they will sometimes have that overlap that are the same whether you're applying either or.
Right. Thank you very much, Dania and Natasha, for sharing your thoughts on today's chat. I really appreciate that. Folks, I've been talking to Natasha and Dania on the interrelationship between IHL, which is International Humanitarian Law, and human rights law and the use of force. Natasha, like I said, is a 50-year litigation U.S. attorney employed at Whitefoot, Taylor, and Preston here in Baltimore, in Maryland, in the United States. And Dania is a licensed attorney in the state of Ohio with interest in public service, human rights, and currently completing a master's program in international law and humanitarian studies at the American University here in Washington, D.C. Ladies and gentlemen, we've come to the end of today's chart, and I do hope to see you next time. Thank you very much, Natasha, and do have a wonderful day. Bye-bye.
Thank you.
Welcome to the Human Rights Café. My name is Jacob Sule. When people's rights are tampered with or denied, it means that my rights and yours are being undermined. Hence, we must educate people about their rights. The Human Rights Café is a collaborative virtual conversation of a Right to Live initiative to equip new generation of leaders to know, promote, and protect citizens' rights and dignity of all persons. The conversation seeks to promote human rights, justice, peace, and strong institutions as provided for by the United Nations Sustainable Development Goals. Our goal is to build a nation where peace and justice shall reign and respect for citizens' rights. If you'd like to know more about the Human Rights Café, please join our conversation on Facebook, YouTube, Instagram, and Twitter via @HRightsCafe. Once again, Jacob Sule. Thank you.